This lecture highlights some of the material in Chapter 10 of the textbook, which deals with contract law. The opening quote from Judge Learned Hand, there really is a judge named Learned Hand. He was one of the most famous of the great intellectual judges, written a number of very famous opinions. So if you see that name, don't laugh at it. It is real. Contract law is a full year course for first-year law students. This is one of the bedrocks of legal education. So the material in Chapter 10 is just a very brief overview of the field of contract law. So if you're feeling a little bit overwhelmed, don't be concerned, because it can be a daunting subject. But we don't expect you to become experts in contract law. This is just an introduction to the topic. And I think the textbook does a very, very good job in covering the material, and in particular with the examples that are given. And just one note, in the textbook has a number of discussion questions and legal reasoning exercises. I can't emphasize too highly the need to read and understand those legal reasoning exercises, give them some thought before you move on. By doing so, it'll help you to understand the material by presenting clear and clear examples of the issues that come up. Okay, one of the things that the textbook deals with is the Uniform Commercial Code. And the Uniform Commercial Code is a model code that was propounded by the National Conference of Commissioners on Uniform State Law. And it's important to understand the Uniform Commercial Code is not a law in and of itself. It's just a proposal for a law from the National Conference. And in this case, the Uniform Commercial Code has, in fact, been adopted in all 50 states, but not in the same way. So ironically, even though it's called the Uniform Commercial Code, it is not uniform. There are variations in the specific sections in every state. So when you're conducting legal research on UCC issues and you're looking at cases from various jurisdictions, you need to make sure that the commercial code section in the jurisdictions are identical. In fact, they could be very, very different. The Uniform Commercial Code is an attempt to govern commercial transactions in all of their aspects. And with respect to contract law, we're primarily focused on Article 2. Article 2A, let me step back. Article 2 deals with contracts for the sale of goods. Goods are things that are tangible, that can be picked up, that can be moved. What are not goods? Land, obviously. Services are not goods. Intangible property, like stocks, intellectual property, patents and trademark, they are not goods either. So Article 2 deals, again, with contracts for the sale of goods. Article 2A deals with leases for goods. And again, those are the things that primarily we focus on in this class. As noted in the textbook, there are certain provisions of the commercial code that apply only to merchants. And merchants is a defined term that you should be very, very aware of. The slide that you're viewing now illustrates one of the issues that's presented by the Uniform Commercial Code. Uniform Commercial Code Article 2 does contain several changes to the common law laws of contracts that continues to apply to contracts for things other than for the sale of goods. And the common law also, by the way, applies to contracts for the sale of goods unless there is a Uniform Commercial Code provision that overrides. So we don't ignore the common law. of contracts. It's alive and well, even in the areas of sales of goods. If the Uniform Commercial Code contains changes. And there are a number of changes that are presented in the textbook that you should be familiar with. When we're dealing with contracts, there are elements of a binding contract, just like we learned elements of torts and elements of crimes. There are also elements of a binding contract, and they're phrased in different ways. The most common way is described in the textbook as a contract must contain at least or must contain an offer. But we call the person that makes the offeror. That offer must be accepted by the offeree, and something of value must be exchanged. And the value element is called consideration, and that's what distinguishes contracts from gifts. Each one of these elements can be further broken down into several sub-elements. So again, if we were studying contract law in a law school, we would break down what it means to be a valid offer, what is not a valid offer. Similarly, how acceptance can be made, and the different types of consideration. And again, some of these elements have been changed by the Uniform Commercial Code with respect to contracts or the sale of goods. But again, coming back just to a legal way of thinking, a legal way of analyzing problems, one of the hallmarks of legal thinking is breaking things down into their elements. That's what lawyers are trained to do. So what does it mean to be a valid offer? There are generally four things that are required to have an offer. There must be parties to it. There must be an offeror and an offeree. The subject matter of the contract must be identified. It can't be vague, can't leave room for questioning. The price under the common law must be set forth. This is one of the areas that the Uniform Commercial Code slightly changes the law. And finally, the time for performance. It's very, very important. So again, parties, subject matter of the contract, price of the item, and the time for performance. So let's look at this video and see if there is a valid offer here.
Introducing the new Pepsi Stuff Catalog. Now, the more Pepsi you drink, the more great stuff you're going to get.
Sure beats the bus.
So the question being, was there a valid offer in that situation? This was an actual real life case in a real life situation where Pepsi, as a joke, offered to provide a Harrier jump jet, which is a type of a fighter plane that can land like a helicopter for a certain number of points. And somebody actually gathered that many points and demanded a Harrier jump jet. Pepsi defended, saying obviously it was a joke. It wasn't a serious offer. The matter was taken to court. And as you might imagine, Pepsi did win. That the court held that could not be considered to be a serious offer. So again, the holding was it wasn't a valid offer, a genuine offer. Acceptance, again, the second element of a contract. Under the mirror image rule, an acceptance must exactly mirror the offer, or the acceptance is viewed as a counteroffer. So if somebody offered to sell you a brand new iPad for $1,000, and you made a counteroffer for $950, or you said no, but I'll pay $950, you will be held to have rejected the offer and made a counteroffer. And again, this isn't with respect to all terms, and it could include the place of delivery, it could be the method of delivery, it could be the timing of the payment, i.e. is payment due on delivery, or is there 15 or 30 days to make payment? Again, the mirror image rule requires an unequivocal acceptance. The UCC has made very minor changes to the mirror image rules, and this recognizes the common situations. Lawyers often use the term the battle of the forms, where perhaps somebody issues a purchase order for 1,000 cases of toilet paper, and the purchase order sets forth the price. And the purchase order provides for payment within 30 days. What happens if the seller ships the goods, and on their invoice includes the price, but instead the invoice says payment is due within 15 days? This is a very, very common situation. So the Uniform Commercial Code it recognizes this and tries to reach an accommodation, recognizing commercial realities. Finally, the third element, consideration. Again, we have to have consideration for there to be a binding contract. Otherwise, it would be considered to be a gift. And consideration can take a number of forms, not just money. It can also be services or goods. Really anything that benefits one party or is a detriment to the other. Again, consideration differentiates a gift from a contract. Questions often come up in court regarding how to interpret a contract, if there's ambiguous language in a contract. There are a number of rules that courts use to govern themselves in interpreting contract. First of all, the plain meaning rule, or common sense meaning, is looked at. If that's not always works, you may try to decipher their intent from how the contract was expressed. One of the common rules, if none of the other ones apply, is to construe any ambiguous language against the party that drafted the contract, with the idea that they caused the ambiguity and they should be held to be at fault. So you would look to see who proposed the language that turned out to be ambiguous, and that would be construed against them. Sometimes we have contracts that for whatever reason are not performed, and the question is there some kind of defense to a contract? And there are a number of defenses that are outlined in the textbook. The defense of contractual capacity refers primarily to minors, but it could also include people that don't have the mental capacity to enter into a contract. And in that regard, people that are, for instance, subject to a court conservatorship, where they've been adjudged to be mentally incompetent, by definition lack contractual capacity and can't enter into a contract. An example I like to give of that, during the time when Britney Spears was subject to her court conservatorship, she did not have the legal right or ability to enter into a contract. All contracts for her were entered into by her conservator. Illegality is another defense to a contract. And that, again, can come up if it's for a contract for an illegal purpose, such as the sale of outlawed narcotics. A legal contract could also come up if someone is signing a contract to do something that they legally cannot do. So, for instance, an attorney must be licensed to practice law. If someone signs a contract to perform legal services for which they're not licensed, i.e., they're not a lawyer, that is an illegal contract. It comes up quite often in the area of contractors law. In California, as many of you know, we have a very extensive contractors license law that requires people to have licenses to perform many types of services. Under California law, if someone enters into a contract to perform services for which they don't have a license, i.e. a contractor's license, that contract is illegal. It cannot be enforced. And in fact, the law goes so far as to provide that any money that unlicensed person might have received can be must be paid back in the event of a lawsuit. Contracts that violate public policy, much like the illegal contracts, again, that's a defense. Lack of consent, lack of an agreement, which come about by fraud or mistake, that can be a defense. And the issue of mistake is particularly important where there's been some kind of radical mistake in pricing. Again, there's a good discussion in the textbook of this. This might come up, say you have somebody that's put out a bid for a construction of an add-on to their home, and they get 3 bids. One is for $80,000, one is for $170,000, the other is for $190,000. Something is obviously radically different about that $80,000 bid, and again, it may be that person made a mistake in their calculation, and the question would be whether or not their mistake would justify or be a valid defense. And again, it's on a case-by-case basis. Improper format refers to situations where basically where the contract under the law is required to be in a certain format. And this primarily relates to contracts that are required to be in writing. And the format we call the statute of frauds. That's just a general term, and that's laws that require certain types of contracts to be in writing, primarily those contracts that relate to real estate and contracts that cannot be performed within 1 year. All right. The last one is defenses includes when warranties were breached. And again, we can have express warranties that are set forth in the contract. As the textbook points out, the Uniform Commercial Code also includes implied warranties of merchantability and implied warranties of fitness for a particular purpose, which would apply if a merchant was involved. So again, review the text materials carefully on the warranties issue. Finally, the text concludes with remedies for a breach of contract. Again, remedies are something that that are included in the first year law school class. Remedies is also a separate class in and of itself in law school, of course, dealing with not only remedies for breach of contract, but remedies for torts as well. So the various remedies are outlined in the textbook, including equitable remedies for specific performance, which primarily occurs with very unique items, such as a painting, Land is always considered to be unique. And so in situations where you do have these unique items that are subject to the contract, a person can file a lawsuit to force someone to go through with a contract. An example of this might be, you think back to a very hot real estate market where somebody enters into a contract for the purchase and sale of a residence, and 2 weeks later, somebody offers $200,000 more for that property. The seller's natural inclination might be to say, "Well, I'm going to bail on the first one and go with the second." However, under the doctrine of specific performance, because real estate is unique, the buyer in the first contract could file a lawsuit and obtain specific performance. Most common remedies for breach of contract are the legal remedies that are outlined in the textbook, and these consist of primarily monetary damages and the different types of monetary damages that can be recovered. Liquidated damages are damages that are listed in the contract, and as pointed out in the textbook, there are certain requirements for liquidated damages clause to be valid. And finally, the person who has the innocent party under a contract or somebody else has breached it does have a duty to mitigate, reduce the damages they suffered. Again, the whole idea is remedies. We have discussed this in prior chapters, so I'm not spending any significant time in this. I do commend you, though, to the textbook, which does contain a very good discussion of the contractual breach of contract remedies. All right, this concludes the lecture for Chapter 10. Again, I can't emphasize too highly the need to review this chapter, and this is one of those chapters I think that warrants rereading, if not once, but several times, in order to get a complete grasp of the concepts in the chapter.